There, we're going.
Oh, okay.
I think other than Chair Davis, everybody who's in this particular meeting is here, correct? I'm looking at the,
I believe so.
there he is. He's in the waiting room. Should I admit him?
Yeah.
Okay.
It looks like we're live, everybody.
Okay, fantastic. And it looks like Chair Davis is making his way in. There he is.
Hey, how's everybody?
We're good.
Morning.
We're just getting started.
All right, I'm actually on Road Boulevard, so I'll be pulling into the garage, joining you from the office. But for now, I am on. I am doing it via iPhone.
Okay, Chair. Well, we're going to see you.
Have the analysts figured out who's kind of leading it or how it?
Yes,
Yeah.
sorry, I had the YouTube stream up, so it was repeating everything that the chair and Senator Augustine had said, so I had to figure out how to mute that. Normally, we have our support staff doing the YouTube stream, so I'm a one-person shop today, so thanks for bearing
Okay.
with me.
Well, I understand.
And if it's okay with everyone, I'll share a screen and we're just gonna do a quick walkthrough of the bill.
Yeah, and Laura, as you're doing that, I would just say welcome to everybody on behalf of myself and Chair Davis. And I also just would offer the opportunity, Chair Kelly, if you wanted to say something.
We don't need to do a whole lot. We need to get to work.
Okay, that's all. I was just offering, Chair Kelly. Sounds good. So Laura and David are going to run through, the parts of the bill this morning. So let's go ahead and get started.
Okay, great. So the first section of the bill is section 31601. This is the definition section. And in this section of the bill, we have definitions for emergency, essential employer, and essential worker. We are going to revisit those definitions a little later in our session this morning when we talk about scope and applicability of the bill. So for now, suffice it to say 31601 is definition section. 31602 is a section of the bill that lays out the scope. So the subtitle only applies to essential employers that are listed out here in this section in certain industries and sectors, and there are 15. So we will walk through that again later today, this morning when we go through the scope and applicability of the bill. Keeps going. Section 31603 is the section that lays out some obligations for the Maryland Emergency Management Agency or local organizations for emergency management. So here, MEMA or a local organization for emergency management is required to periodically evaluate and determine whether an emergency is occurring. In this section, if the agency determines that an emergency is occurring, the agency has to announce publicly in writing that an emergency is occurring and that essential employers must comply with the hazard pay, health insurance coverage, and leave benefit provisions of the Act. And then when the emergency has subsided, the same agency has to announce publicly in writing that essential employers no longer need to comply with these provisions of the Act. Section 31604 is general requirements for essential employers. So this is, Dave and I have categorized the different sections of the bill, and that's how we're going to be doing each of the meetings. So the prior section was an obligation for an agency. This section is one that lays out obligations for essential employers. So under this section, essential employers are required to provide working conditions that reduce physical harm and mental distress and detriment and ensure physical health and safety. Also required to provide necessary amounts of personal protective equipment at no cost to essential workers. required to create and maintain written protocols to enforce any necessary hygienic practices or disease mitigation measures at a work site, and provide or implement any other measures or requirements to ensure the general health and safety of essential workers. Moving along to section 316.05. This section is about refusal to work at an unsafe work environment. This section lays out obligations for an essential worker, an agency, and an essential employer. So the section begins by defining what constitutes an unsafe work environment. The section further authorizes an essential worker to refuse to fulfill a responsibility that is required or encouraged by an essential employer and that relates to an unsafe work environment if two conditions are met. If the worker fears for the essential worker's life or health during an emergency due to the nature of the work being performed, and if the worker promptly notifies the Commissioner of Labor and Industry in writing within 3 days after the date when the essential worker became aware of the condition that caused the unsafe work environment. This section also requires the Commissioner of Labor and Industry, so let me go down to that part here, requires the Commissioner of Labor and Industry to promptly notify an essential employer of the content of a written complaint, and then in its discretion set forth requirements that the essential employer must meet to effectively and immediately remedy the unsafe work environment. The Commissioner is also required to assess a civil penalty under certain circumstances, and let's see. Actually, that's authorized. Here you'll see if the Commissioner determines there's been a violation, the Commissioner may, in the Commissioner's discretion, assess a civil penalty of up to $1,000. This is an error here for applicant for employment should read for each essential worker for whom the employer was not in compliance. And then there's other specified enforcement actions that the Commissioner may take. Let's see. The essential employer is prohibited from retaliating against an essential worker or any other worker for taking specified actions like filing a complaint. And an essential employer is required to comply with any standards that the Commissioner requires, including an emergency or temporary standard. The members will remember that there, well, at least in the House, there's separate legislation to set up an emergency COVID safety standard. And so there's also talk on the federal level about OSHA establishing COVID safety protocols broadly for workers. So this is designed to leave open the possibility that there may at some point be an emergency or temporary standard specific to COVID protocols. Section 316.06 is the Health Emergency Preparedness Plan requirement. This is an obligation for essential employers. So this section requires essential employers to prepare a health emergency preparedness plan and to annually review the plan. The section specifies the contents of the plan and then requires an essential employer to display the most recent plan in a common area visible to all workers and submit changes to MEMA and the relevant local emergency management agency on or before December 31st of each year. Section 316.07 is the section about minimization of risk of transmission of infectious diseases. This is an obligation for our essential employers. This section requires an essential employer to take specified proactive steps to minimize risk of transmission of infectious diseases, to pay all costs associated with testing for contagious illness or disease during an emergency, and to report all positive test cases to the Maryland Department of Health following specified protocols, including identifying demographic information and redacting personal identifying information. The section further requires the Department of Health to collect positive test results, categorize those results by industry, and publish the results in a format that is readily accessible to the general public. The section also requires the Commissioner of Labor and Industry to adopt regulations as necessary to carry out those provisions. Section 316.08 is the section about health and bereavement leave. This is categorized as a benefit for essential workers. So this section requires an essential employer to provide at least 14 days of paid health leave for illness or health needs related to an emergency. The section also requires an essential employer to provide at least 3 days of paid bereavement leave for the death of a family member. The definition of family member is the same as exists under the sick leave law, the Maryland Healthy Working Families Act. And the death would have to have resulted from the emergency. This section also contains a few construction provisions. So it says that the act may not be construed to allow an essential worker to take leave consecutively with earned sick leave, sick and safe leave, or to prohibit an essential employer from providing additional bereavement leave, health leave, or any other type of leave. Section 31609 is a section of the bill that covers hazard pay and financial assistance with healthcare costs. This is categorized as a benefit for essential workers. So this section requires an essential employer to provide hazard pay of $3 per hour worked for essential workers. This applies to workers making less than $100,000 per year. So there's a cap on who can earn and be entitled to receive the hazard pay. In general, the hazard pay requirement is retroactive to the start of an emergency, but in this current pandemic, workers begin earning hazard pay on the date the bill goes into effect. There was a lot of discussion about that at the ECM hearing, not sure how it was in the Senate, but the sponsors were clear that because the pandemic has been ongoing for so long, they recognize that the retroactivity would be a difficult requirement for employers to comply with. So in this case, if the bill were to pass with this hazard pay language, the hazard pay workers would begin to earn it the day the bill goes into effect. This section of the bill also requires an essential employer to reimburse an essential worker for healthcare expenses like co-pays, insurance premiums, out-of-pocket costs of medical coverage or transportation costs, and also facilitate an essential worker's access to coverage on the Maryland Health Benefit Exchange. The section specifies that covering benefits under the Workers' Compensation Act satisfies the requirement to assist with healthcare costs, and specifies that hazard pay and financial assistance for healthcare costs may not be counted towards an essential worker's eligibility for state means-tested benefits programs. Earlier up in the bill, scroll back up to page 2, there's a related provision about the health benefit exchange. So section 31108 of the insurance article is being amended here to establish a special enrollment period on the Maryland Health Benefit Exchange for essential workers who do not have employer-sponsored group health coverage. And then if we go back down to section 31610 of the bill, this is the provision, this is classified as a protection for essential workers. This section prohibits an essential employer from intentionally or unintentionally misclassifying an essential worker as an independent contractor or any other classification in order to avoid paying an essential worker the hazard pay required under the bill or any other benefits owed during an emergency. The last section is there's a few more. Two more. Section 31611 is the section that covers enforcement and remedies. This is also a protection for essential workers. So the section establishes a 2-year period for filing complaints with the Commissioner of Labor and Industry, requires the commissioner to investigate on receipt of a written complaint, authorizes the commissioner to investigate on the commissioner's own initiative, and requires the commissioner to keep the identity of the complainant confidential unless disclosure is necessary or required by law, and to the extent practicable to notify the claimant in advance of the need to disclose the complainant's identity. The section also requires an essential employer under investigation to comply with requests from the commissioner. The section requires the commissioner to issue an order compelling compliance, and then requires the commissioner to impose a civil penalty of not more than $1,000 and award compensatory damages and any other relief necessary to make the current or former employee whole, including rescission, reinstatement, back pay, and attorney's fees. The section also specifies that each violation is imposed on a per essential worker and per instance basis. And section requires the commissioner to consider various factors when determining the amount of a civil penalty. The last section of the bill is section 316.12. This is just the short title. So the act may be cited as the Maryland Essential Workers Protection Act. And then you'll see below that in the uncodified language, section 2 is the provision that says it's a prospective application clause for hazard pay. So that's to make it clear that in the current instance, the hazard pay requirement goes into effect on the date the bill goes into effect. And then the last uncodified section here is making the bill an emergency bill. There's one other provision at the beginning of the bill that I just wanted to note. It's amending the labor and employment article here. So this is requiring an employer to provide written statement of hazard pay for each pay period if applicable. So it's adding to basically a pay stub requirement that now if an essential employee or worker is earning hazard pay, that information would need to be included on the pay statement. So that is the quick and dirty run through of the bill. I don't know how the chairs would like to proceed from here. Dave and I are kind of prepared to talk more about scope, the definitions.
Any questions?
Yeah, any other general questions?
Basically, other than the focus on the emergency leave here, a lot of the bones of this type of leave is you've seen before in other pieces of legislation. So, you know, the ability of the commissioner to investigate action and all that other items in this bill, you've seen some versions of, and you've had bills in before regarding adding the pay stub requirements. So there's what's unique about this, obviously, is its focus on emergencies and special provisions relating to emergency that would only come into place when there's an emergency. Two types of emergency, basically, under the bill.
It does occur to me that we don't at any point seem to go with what the causation is of the emergency and the ability of the employer to do all that is required. Is there some kind of a test? Because we don't want to put them out of business unless they really are a bad employer.
I'm sorry, Kelly. Can you give the question again? I think I may have misunderstood.
Yeah, I was just asking a couple of things. One is, do we deal anywhere with some kind of a test of what the employer has the ability to pay? If you put the employer out of business, unless it's really a bad employer altogether, any of this be forthcoming?
Are we talking about on the provision of hazard pay or just in general?
Well, I'm talking about in general, because there are a lot of things the employer during the emergency, the employee is experiencing the emergency, as is the employee. And I'm just wondering, unless it's something that the employer caused, the employer could cause an emergency.
I'm not aware of any tests of the ability of, not in this legislation, no, there's no test on that can be applied to each employer or to groups of employers on whether they can actually meet the financial obligations in the bill.
Well, I guess in the final analysis, we want it to be something that is doable. If we run some of them out of business, unless they on other bases ought to be out of business, then can they fulfill any of this, and then the employees are hurt? So I guess I'm wondering.
Something like an undue hardship provision.
Well, some kind of a test.
I guess I would say this, and that's
we want to do what is reasonable for the employee without putting the source of the assistance out of reach, so that they can't do anything for anybody.
No, that's a fair question, Senator Kelly. I certainly understand that. I guess I would start by saying, when we have like these sort of states of emergencies, I don't believe by and large they're going to be anyone's fault, be it the employer or the employee. I mean, it could happen, but the current one, for example, that wasn't anyone's fault. It just sort of happens. Then there's certain points you know, that are obviously are points of contention. Hazard pay, you know, and that's something obviously we need to talk through and debate. But I think there's certain other things that, like, when we require people to come to work or to show up, there's certain protections I think that just goes along with that. Certain, for example, personal protection equipment and leave, you know, a certain leave. For example, with this, I think generally if you've contracted the virus, they want, you know, it's a 10 to 14 day period that they are not working. So I guess I would look at it like, if we're requiring them to work and then in the course of that, they contract the illness, we can't then just sort of ignore the fact that they caught that. I mean, it's almost like a presumption that if you're being brought into that type of work situation, that you have that issue. And the same thing with personal protection equipment. To me, I view that as like a tool, part of the tools of the job. If we look at the House and Senate, for us to come to work, they have the, you know, the plexiglass stuff all over the place. We are socially distanced. Look at us now. We're doing our job and none of us are around anybody else.
Right.
We are safely in our offices or our homes performing our ability. So I guess what I'm looking at is, I certainly agree with you. We can't, in trying to do some good, do harm. Do no harm, I guess, is the thing. So I'm with you on that. For me, coming from, just one perspective, I was just thinking that we at least need to establish a floor of what the expectations are if we're pulling people into certain situations. And just to be clear, and once again, we're not talking snow emergencies and things of that nature.
Let's say
type of things we're
corrections,
doing.
state corrections. And that's a terrible environment to have to work in ordinarily. And then under these circumstances, and without PPE and all, I'm just looking at what we didn't do this time. Well, that isn't so much my word, because the state has to do it if we pass the bill. But I'm thinking, if it were a private employer, do we want to have some tests or some ability not to put them out of business in the middle of the emergency, by the degree to which we're asking for returns during that emergency, such that then there's nowhere to get anything from? And that's what my question is really about.
Chair Kelly, I just would say to that, Chair Davis, it's okay. I think that I appreciate what you're saying. I think it's important for us to have that in mind as we are going through the different parts of this bill, some of which do have a financial cost. Some may be beneficial to the employers as well, if we're able to get MEMA to do some things. But I do understand what you're saying. I think that you are also you're honing in on the fact that it probably isn't going to be a one size fits all. And so I think that's part of this process. So I definitely appreciate what you're saying. I think it should be a part of this process as we are kind of going through and figuring out the things that we feel are applicable to everyone and everyone should be able to do to protect the workers, and some of the other ones that may need some additional protections or additional elements like you're talking about. So I definitely.
I was even wondering if we want to offer employers some kind of hazard insurance in Maryland, so that they don't run out when they need to be doing more because we're in an emergency.
Wasn't that an issue? Correct me if I'm wrong, Laura, that workers actually, there was an issue going on in the state now. The businesses thought that they had purchased some sort of stop work or some sort of catastrophic insurance but as it turned out, it didn't cover a pandemic, or am I confusing something?
I think there's an issue maybe in the property and casualty insurance area where the insurance policies aren't, I don't know, our vice chair might know more. I think that maybe, is that what you're talking about? There's an issue where some employers have purchased insurance that doesn't cover public health emergencies. So in
Yes,
that way, they,
it was something that was brought to our attention this time,
right.
that employers thought they were covered.
Mhm.
They had purchased insurance, but then they were told later that, but it didn't cover a pandemic. I'll get
Right.
that straight, but yeah, I think that's a good point you
But we
raised.
need to be able to do everything you got in here that you want done. I'm just saying, while we're going along, we need to look at, will we inadvertently undermine what is necessary in terms of financial wherewithal of the employers so that they can't? Because it would be terrible to have the workers depending on something in the middle of the pandemic and saying, well, it's here in the law, and have the employers just going out of business because they can't. And so at some point we need to think about, especially for smaller employers, what we can do while we're working to make sure there is the wherewithal to deliver.
Understood.
Chair Kelly, can I feedback on that just a little bit, if you don't mind? First off, the insurance part, that's an exclusion in the general liability part. So anything that was a virus or a pandemic, epidemic was specifically excluded in all of our insurance policies. Know for sure most business owners, when this first came about last April, May, they were calling their insurance companies and saying, hey, look, I think we have coverage for this sort of thing. And then they find out that it's not there. And of course, the insurance companies are saying if they ever offered that kind of coverage, it would be nearly impossible to finance it because of the sheer volume of claims that would come about through a pandemic, for example.
And the sheer volume of claims won't go away if you don't have the insurers doing it, if the employers are doing it directly.
Oh, I'm just sharing. I'm just sharing the explanation that was given that the
Okay.
volume of claims, there's no way to mitigate that risk through premiums. So the other thing in feedback is, when the governor declared the emergency, it wasn't much later that the federal government backed up the businesses with PPP loans, and the state did some loan programs, grants as well. And so, businesses, of no fault of their own were being closed, but that was a massive financial obligation that the country put forward to help businesses stay alive. And there was a second round of PPP that frankly is being paid out as we speak, which speaks to not only what's happening when the pandemic is in effect and it's at its worst, like it was last summer, but rather that the business behavior, the consumer behaviors, the nature of commerce has a tendency to change and change permanently. So anytime we have a pandemic, and I'm assuming that we're thinking about this as through the next pandemic, anything that the state's going to do through a government mandate, this is an open question, and I think you're asking this is how do we, in a way similar to how the federal government did through PPP, how do we make businesses whole through no fault of their own? So that's an open question that I think just adding to your.
We want to be sure they have the ability to do what we're saying they need to do.
Madam Chair, if I
Some will be flowful, but some just, yeah.
if I could add too, and based a little bit on what Chairman Davis mentioned, we're all have figured out a way to operate the General Assembly based on these pandemic conditions. And we did so without a bill, without a law, without regulations. And what's also interesting is we've done it differently. The House is doing different things from the Senate is doing. We both have figured out on our own how to keep and protect the employees of the General Assembly without having all of this. So where did the premise come up that businesses just don't know how to care and protect their employees? That seems to be the starting point of all of this. And I just don't know how we got to that position given who we all are and given what we've gone through and what we go through on a day-to-day basis, why is the assumption that businesses can't take care of their own employees without regulations like this?
Well, I don't know about that question, but I'm simply saying that there's so much variability in the sizes and types and the financial wherewithal of various businesses that could have essential workers in need during a pandemic. And unless we think about either some tiers or some levels of responsibility, or some, you can't do what you can't do, and you want to be sure as we go along. That's all I'm saying. That what we ask, we're trying to figure out how it can be done without the businesses all collapsing, or a lot of them.
I agree, Madam Chair, and I think that this bill is extremely prescriptive in what needs to happen for really no reason. Again, nobody put these regulations upon us. We're considered essential workers. We have to be able to go to work every day and to be safe. And we were able to figure this out on our own. And I'm just concerned that something this restrictive gets us into a position where businesses can't afford this. Keep in mind, this is all in place. You know, all of this conversation is not because businesses made decisions to shut down or not because businesses introduced this pandemic. They are reacting to that the same way everybody is, and they're doing the best that they can. And I think something that's this broad and this prescriptive is going to do somewhat what you said, Madam Chair, as potentially put some businesses out of business, and therefore you have employees that will not be working anymore. And I think this could do more damage.
Okay, so if I could just jump in just on that a little bit, and I appreciate what you're saying, Senator. I think that you're getting a field, for me at least, of what I shared, at least is the essence of this for me, which are, yes, I understand a portion of what you're saying, but there are these essential workers who have put their lives on the line for you and for me, that allows us to hold this meeting in this way. But they do not have a choice in that. They are public facing, and they cannot control what the public does. They were a part of the supply chain that allowed us to eat. We had no choice on that. They had no choice. They had to face the public on that. We can't control that. This is a controlled environment. Theirs is not. We asked them to take care of us when we are sick. They also have to face the public in that instance and put their lives on the line. And they've died in those situations. And so there is a need that has not been met there. And I at least receive call after call, Senator, of individuals who are those frontline workers who have not been taken care of in a way that has made them safe. And that's the reason why, to me, that's what this is really about. I mean, that's what this is about. And we can debate this for quite some time, or we can go through the places where we can agree inside of this bill, find those places where we have that, find some places where we can then say, hey, maybe this does need to be moved, this does need to be changed, or doesn't work given some of the circumstances that you all have talked about. But I think that that's what's going to be a more useful use of this group and of this time, is for us to be able to do that. So I just wanted to put that on the table.
And Senator, I can agree with a lot of those. And I did specify or specifically say I wanted to ask about that broadly. There are certainly ways that we can come to some agreements. It's just sometimes when we get to these types of legislation, the broader premise is that somebody, or at least in this case, all essential employers are doing it wrong. And I don't want to start with that premise because that's not accurate. You're right. There are some that may be wrong, that may not have been protecting their employees, or their essential employees are in a much, much more unsafe environment, just from the fact of that's the type of environment they work in. But I just didn't want to go with the premise that all employers are doing it wrong, because I think there's a lot that are out there that have taken extraordinary steps to make sure that they protected their employees.
If I can, guys, what may be helpful, and I definitely agree with Senator Hershey, it's just that, like, when we make laws, for example, 99% of the people pay their taxes. but we have to have laws for the 1 to 5% that don't. Most people don't go out committing crimes, but we have to have laws for people who don't or who do. So I think what may be helpful in this situation, because it feels like third reader debate on the bill at this point, what I'm thinking, if maybe we can go section by section and just discuss what's in a given section and see, well, okay, we can agree on this, or we can't, or we can't, if we don't agree, why? And, maybe we may be able to resolve some things, maybe as written, it's a problem, but if it was written a different way, we may be able to come, not necessarily even agree, but, we can sort of bridge that divide a little bit, as opposed to maybe discussing it, as written and overall, because I'm not sure if that, if that's the best use of everyone's time. Again, that's more of a third reader debate. So if we want to at least give that a try, maybe start it on a particular section, Laura and David, as you guys outlined it, maybe we take it by section and just ask, what are the problems with this particular provision? And if there's a problem, how will we do it differently, or should we not do it at all? Maybe that may be a bit more productive.
Is the group okay with that?
Sounds good to me.
Fantastic. Thanks, Chair Davis.
We thought you would start. I mean, we don't have to worry about like I don't think our plan was to go through the bill, page by page, that we would go straight to Laura. I think we thought we'd start with the definition of, where most of the contention was in the hearing, was the definition of emergency, and then the scope of the bill, who's in, who's out.
Yes. So this is the definition of emergency as it appears in the bill. So emergency means an imminent threat or occurrence of severe or widespread loss of life, injury, or other health impacts, property damage or destruction, social or economic disruption, or environmental degradation from natural, technological, or human-made causes, or an incident, occurrence, or outbreak that is the subject of an executive order, an executive declaration under Section 14107 of the Public Safety Article, or an executive proclamation under Section 143802 of the Public Safety Article.
So basically, the first part of the definition is a very all-encompassing type of emergency threat. I think you're basically operating currently under number 2. That would be more the emergency you're operating under now, would be number 2, part 2 of the definition.
There any concerns with this definition?
Yeah, David, this is Chris. Number 2, which one of those subsections did the governor use for the past?
Well, I know you're under an executive order, and you're also under, I think he used, I'm not entirely sure, I wasn't really involved with this, but I think he used all of these at some point. Yes, you're operating under 14107 of the Public Safety Article. And I also believe he must have done some other actions too here to govern this. And you also passed legislation too to give him these powers. So in some manner, you've given the governor the ability to implement all of these things through legislation. He had the current power already to do some of these things also. So
2 observations. One, any of the emergencies that are listed, you could almost surely see the governor declaring an executive order. And so I would think that by broadly defining emergency through this multi-stage definition is overly broad, you could tighten it up by just saying if there's an executive order that the governor is addressing this. And I'm not sure exactly the difference between a declaration and an order. I guess I would need some guidance on that, but that would be my first, blush at this. And then the other question is every executive order or emergency, and this is a question, worthy of having this piece of legislation become effective? So I'm imagining scenarios where, some of these emergencies may come up or an executive order may come up. And does that necessarily mean that we need to have such a massive mandate being applied to private and public sector.
This is Kathleen, and I tend to agree, or Delegate Dumais, whichever we're doing, and I tend to agree with Delegate Adams, which doesn't happen often, but I think that the lines 19 through 23 are just way too broad. I don't know where the definition came from, but if we, if we're trying to define sort of say a public health emergency, that is an incident, occurrence, or outbreak, and that is subject to an executive order or whatever, I think we need to limit it. I am really concerned that I don't think I would know when a public health emergency occurred or when this act goes into effect based on number one, lines 19 through 23. I mean, I think the important thing is for us to narrow the scope for what this is going to apply to. We've never experienced what we've experienced in the last year. But trying to expand it too much, I think is going to be too hard on businesses. So I would strike 19 through 23, and we should work on the second one that just is, a public health emergency, incident, occurrence, or outbreak that is the subject of and let the executive order trigger when this goes into effect.
One thing I just wanted to add to that point from Madam Vice Chair is that when I was working on drafting the bill with the sponsors, to make clear when this language in lines 19 through 23 is triggered. That was why section 31603 of the bill requires MEMA or a local emergency management agency to periodically evaluate whether an emergency exists, and then make a formal announcement that it's triggered on. Basically the leave and hazard pay provisions are triggered on. So the bill does include that so that there is an affirmative, clear message to employers that they would need to comply. Whether or not, the work group is satisfied with that is a whole nother question, but the bill does contain that, so it's not ambiguous as to whether an emergency exists and employers would need to comply with the act.
I would agree with Vice Chair Dumais on this as well. I think this is overly broad, and Laura, the next reason for I think leaving it, taking that section out and leaving just number 2, that this has to be initiated by the governor, goes back to what you just said, and that's the whole part of all of these other agencies trying to determine whether an emergency is occurring or not occurring. Again, if this is an emergency, I would imagine that the governor is stepping up and saying something about this and making that declaration. I think that will, if we left it to just number 2 of this section, it would be able to take out the other part on who determines it's an emergency. We want this to, this should really be an emergency if we're going to go through all these steps. And the person in charge of declaring emergencies for the state of Maryland is the governor.
Yeah, and I agree. And I'm not sure if that's the case, then I don't know if we need, I appreciate, Laura, the reason that you put in 1603, and that does make sense, but I think I'm more comfortable with it being an executive order that triggers everything going into effect. Not that those agencies that you mentioned in 1603 aren't important and aren't going to have some instructions, but I don't know if I need them to be the trigger.
Exactly.
Yeah, the governor can consult with them.
Of course.
So
Anybody else have some feedback on this?
Yeah, I guess please don't let this just be a House Senate discussion.
Yeah, that's why y'all are here.
That's why we.
For the record, we strongly agree. We brought this up in testimony in the hearing.
And I mean, I think that's something that we agreed to. We can definitely work on that definition. I think the suggestion that Vice Chair Dumais made is a great idea.
Okay.
I would, I think there's agreement on that.
Yeah, same from the chamber.
Okay.
Obviously, by the way, I'm David Harrington from the Prince George's Chamber of Commerce, and so we would agree.
and former state senator.
That's right.
Yes, sir.
My former state senator.
Yes, sir. And I served with Chair Kelly.
Yes, yes, you sure did.
Yes, ma'am.
Let's move on to maybe the next session, second point, and see what we can do with that.
This is going to be the fun part.
So this is the definition of essential employer. So essential employer means a person that employs an essential worker and includes a unit of state or local government. And then I don't know if in order to understand who's an essential employer, you have to go down to section 316.02, which says the subtitle applies only to essential employers in the following industries and sectors. And then there's 15 that are identified in the bill. So do you want to go through those? Or?
Let me ask a quick question, because that sounds like it may be one of the biggest points of contention that we have to go through. Are there, if Madam Chair, Senator Augustine, guys, if you all feel different, are there less complicated or complex issues that maybe we could try to tackle and sort of put that, that most difficult one back, maybe either the next time or whatever? My guess is we're going to get bogged down on that point, work through that. And I was just wondering if maybe there are other things that, that may be easier to tackle that we can through and then double back on the definition of who's essential at a later meeting or not.
I would definitely support that. I think that's a good use of everybody's time this morning.
And I think I would just ask Laura and David if before we tackle this section, if one or both of you can get from the current executive orders, or primarily the first executive order, how the governor defined essential workers in the executive orders. It was narrower than this, and I'm not saying we have to accept it, but it would be helpful to see that.
I don't think the governor ever included mass transit operators.
Right.
And they certainly are essential. Everybody, they have.
I don't disagree with you at all. I'm just saying if we have his list, we can maybe start from there, and then sort of see where there's overlap or where there's not and who we need to add. I absolutely agree with you, Senator Kelly.
Vice Chair DeMay, the list came from the federal government. It was a CDC document. And so the first thing us business owners did when this executive order came down was, based on that executive order, go to a website that the federal government had. And let me say that was a very broad and encompassing document, more broadly than you might imagine.
Okay.
If I could,
it'd be helpful to have too.
Yeah, I would like to comment on that too, because it does come straight from the CDC with some minor changes that I was going to bring up. But if you also recall, in the emergency, several of the executive orders, and in talking with employers as well as the state, they constantly kept deferring to CDC regulations. So I think we'd have to be clear. Are we going to defer in our executive orders? Are we going to allow employers to say, I'm following CDC regulations, and then not include them in this bill? Or, is Maryland going to have its own definition, or are we going to go by the federal government? That would be something to decide too, when we do come back to this section.
And we got to remember the feds can print money and we can't.
Well,
Sally,
that's
you
true.
have your hand raised? I'm sorry, y'all, but Sally's has raised her hand. She's not.
Good.
I do, and I know. Oh, now I'm going crazy with my reactions. I know we're anxious to move on, but I did just want to point out that the section above in D1 actually defines essential worker, and 316.02 is somewhat superfluous in attempting to delineate it. So I would suggest the simplest thing is to just go with the definition that's already there in D1 and delete section 316.02. But
that's about a third of the bill.
Yeah. I don't think we're going to be able to, that's just me. I understand what you're saying. probably that portion is probably going to be something we're going to have to work on too. But I think that there's an understanding that we're going to have to take a look at who look closely at who is being defined as an essential employer and then an essential worker.
Well,
Given what we're
really-
asking them to do, given what we're asking businesses to do, I think that we know that we got to do that. Just given what we're going to be asking them to do.
Right, and I understand we've heard a lot about businesses this morning, and I understand Senator Hershey's feelings that this seems very anti-business, and that's really not the intent at all. The reason we're here today is because we didn't flatten the curve. And the pandemic just kept on going because there wasn't enough done. And, we have to remember that it's individuals, it's families, it's parents who are going to work in these essential jobs. And so there's a balance to be made. It's not I think some folks are taking the approach that this is an either or us versus them. And that's not it. We're all in it together. So there must be ways to figure out how to pay for this without putting essential employers at risk, or finding creative ways to fund them to help them out. Under the federal law, when there was sick leave, businesses could apply or seek reimbursement from the federal government. So I hope that folks can come together and sort of work together to find ways to both help the businesses, but remember that it's the individual employees that are really powering the economy and keeping the economy going. So that's, I know folks want to move on, so that's just my 2 cents. Thank you.
Thanks. No, I appreciate that. Can we do Laura? Can we?
Yeah, would you like me to move on to another section?
Yeah, I think that was a good lead by Chair Davis.
Okay.
The sections are, some of them are going to be just as difficult as who's in and who's out, and that would be, the employee protections, and then you've got the employee benefits, and then there's the enforcement. If you want to break it down broadly into what this bill's about.
If you wanted to look at this section here, we discussed it a few minutes ago, 31603. This is the section that establishes obligations for MEMA and local emergency management agencies. So if the work group is inclined to recommend removing that first part of what's defined as an emergency, then we may need to make some revisions here because I guess you all would need to decide whether you think it's appropriate or necessary for these agencies to periodically evaluate and determine whether there's an emergency and then make these proclamations. It may not be necessary if it's going to just be triggered by something that the governor is doing.
I think we're in stronger position to stick with the governor's proclamations.
Right.
And I think we could use this section to say this is what they need to do, and then they need to tell the governor that he needs to do, or she needs to do something.
All of that could take forever with them conferring and meeting. I think putting it.
And I'm okay striking it, but I'm just saying, if we wanted to be sure they were involved in some form or fashion, it's sort of like they need to periodically do this and then communicate what their findings to the governor.
Yeah, so kind of in keeping with that, I think that there is a part of this section where the agency does have a role in just publicly writing that emergency is occurring and communicating, being a vehicle for communication to employers. I think that there is a role for that in this process. And maybe that's something that we need to look at.
You could simply just, instead of an agency, say the state, not define agency, and just say the state shall, if the state determines, because the state is the governor.
Yeah.
You could say the state, or you could say the governor, substitute agency for governor.
Mm-hmm.
And that would move along with the proclamations and everything else that he has, that he or she would be doing in the first part of the bill.
I think that's the best way to go. You can put your hands on something.
To that point, really quickly, just because a declaration or state of emergency could include a snowstorm, for instance, are you narrowing it then to MEMA perhaps? Because like the Department of Health knows nothing about a snowstorm. Like that's still how broad that original definition of emergency is. So I just want to throw that out to the group.
Well, I think that initial definition needs to say sort of public health. Let me get to page 1 again.
Yeah, we're going to work on that. I agree.
Yeah,
with,
where it is, it would
Chair
sort of be, a public health
Right.
emergency incident occurrence or outbreak that is subject of an executive order, so that we limit it to public health, so it can't be considered.
Absolutely.
Maybe somebody could
Mhm.
call a snowstorm a public health if it was a blizzard and things were shut down, but it's still, I think we're trying to address a pandemic.
You
or
are
whatever.
thinking of something that's prolonged and very significant and impacting broad expanses of the public due to no fault of their own, and snowstorms we're used to.
And sort of not weather related, if we needed to sort of
Right.
add that language to make it clear that we're not talking about, not that hurricanes aren't awful or whatever, but that this was an infectious kind of incident that we're talking about.
And also like not the flu, right? Because
Yeah.
I don't know, almost 100,000 Americans can die from the flu every year too, for example.
Unless there's some wild strain that is, becomes,
Right.
technically coronavirus is a flu virus. But you're right. We're not looking for the standard flu. We're looking for the.
Into the future, we can say a pandemic or something that is not historic and old, and we've been dealing with it for decades.
Right.
I just want to echo what the Vice Chair Demay said. I think the public health portion of it does kind of capture it, and we could definitely work on that language.
Sure.
I do agree. I do agree that captures sort of the spirit of what what we are agreeing that we want to do.
If I may,
I would agree.
I would agree with that as well. I think that the governor would receive advice from the public health officer, who would then in turn be in touch with the federal government on the level of the pandemic that is affecting not only the state but also nationwide. I think that makes a lot of sense. So the governor's just not going to haphazardly just pass an executive order. Obviously, he or she is going to seek guidance from the public health officer, who is going to be in touch with the federal government to make that determination, which makes, I think, a lot of sense.
There's some testimony that uses the phrase state catastrophic health emergency proclamation. I think by saying catastrophic, we're not talking about a regional hurricane. We're talking about something that affects Garrett County the same way it affects Somerset County, the same way it affects Baltimore City and Montgomery County. So, so just because an executive order is being issued, there should be an additional step that I don't know what the legal ramifications of staying state catastrophic health emergency, but I think you narrow this down to a pandemic for sure.
Yeah, Delegate Adams, we would agree with the introduction of the word catastrophic as part of the definition. I don't know how public health emergency is currently defined in code, but adding catastrophic would eliminate some of Kaylee's concerns, which is, the flu, et cetera, et cetera. So we would agree with adding the word catastrophic if appropriate.
As I think we said, we will take a look and we'll work on this. I think we understand sort of like the direction. We could definitely work on it. See, Laura, you want to do you have a next section that we can look at?
Yeah, so section 316.04 is sort of in the broader category of obligations for essential employers. So this section lays out some general requirements for essential employers to provide working conditions that, reduce physical harm and mental distress and detriment and ensure physical health and safety, provide necessary amounts of PPE at no cost to essential workers, create and maintain written protocols to enforce necessary hygienic practices or disease mitigation measures at the work site, and provide or implement any other measures or requirements to ensure general health and safety of essential workers.
The cooks and waiters in the neighborhood restaurants have become essential employees. Without them, a lot of people wouldn't eat. And even the boxes of food that are being given away to people that are unemployed are often coming from places like that. But a lot of these small restaurants are one of the hardest hit businesses. So we need to think of the type of bill. We may need 2 or 3 tiers in the bill to determine both in terms of the number of employees that a business would have and the vulnerability or lack thereof of the particular business category.
I would proffer here to follow MOSH and OSHA guidance. On line 21, reducing physical harm and mental distress. That is so subjective. So that's something that we would want to see struck in this section. But obviously, ensuring physical health and safety is very important, but we have numerous laws and guidelines that employers must follow on a daily basis. And then just while we're talking about this section, there are major supply chain issues that occurred with PPE, not to mention the cost. So this is another area that we have significant problems with as well.
Kaylee, if I can, at least half of one of the 2 points you made, would language something akin to subject to availability or that kind of thing? I mean, if there's a total disruption or it's clear that it's very difficult to get, I think we have to be reasonable or, with that sort of thing when it's just clear that we can't get it, i.e. a little bit, let's take the vaccine, for example. It's clear that there's not enough for everybody. So, I mean, just sort of trying to parallel with that, you can't get blood from a turnip. And so I don't think the intent would be if it's just simply not there or it's scarcely available that, and I don't know how to thread the needle just yet, but I think there's a difference between it not being available versus we're not purchasing it or doing it or what, whatever the language may be. So I don't know how everybody else feels about that, but some sort of provision that if it's just simply not, just not enough out there. And I think at one point in time, what was it? We were hearing that there weren't enough masks that were available. So, I mean, I think there's some way we could take that into consideration.
I would also add maybe something about undue financial harm. And then like, what is the expectation that on a daily basis, the employer is providing all of it? Well, what happens if the employee has their own masks and all that? Do we still have to provide it? I just have a lot of questions about how that works.
Yeah, I would add from our perspective, we have a bunch of questions too. For example, what does necessary amount mean and who determines that? And then also who's determining what PPE is necessary? What guidance are we following in terms of what PPE is necessary based on the definition that we use for emergency? So even in the instance where we change the definition of emergency to capture sort of public health emergency or catastrophic public health emergency, each public health emergency is going to look fundamentally different, whether it's airborne, foodborne, waterborne. And so who's making the determination on what PPE is necessary and how much is necessary? But I would agree, Chairman Davis, the subject to availability language is something that we introduced in our testimony and would be a good start in starting to clear up some of this for our members.
And I guess for the people out there that I know are listening to this conversation, as you hear issues and so forth, feel free to send it to Senator Kelly or Senator Augustine, your suggestions and comments. You can send them to me as well. Send it to us as well. I mean, if you all have any input or ideas about the things that we're talking about that could get us there, respectfully, I think that would be helpful, and certainly that's something we can consider at the next debate. So
Sorry, Chair, I just wanted to jump in really quick. I think the subject to availability, I understand the issue that's being raised, but I guess on the other end, then that would mean that we would be requiring workers to come to work without masks. So if they can't get them, are they still going to be required to come to work and then perform their duties if they need gloves, if they need masks? So I understand the concern, but I just think on the other end, we also have to, figure that out, because then workers are going to be even more exposed if they don't have proper PPE.
And if I could just add to that, this seems like something that could perhaps be negotiated through regulations. I have serious concerns that language like if available just creates a loophole, and without the obligation, there are businesses that are going to prioritize other things than buying PPE. And I think this gets back to what I was saying earlier, is that I think the better approach is to work together to find ways to help the businesses afford these things, not to relieve them of the obligation to take care of the workers that are keeping the businesses running.
Tally, I don't think that's what they're saying. Go ahead. I'm sorry, Senator David.
No, Mr. Chairman.
I know they're not saying that.
No, I've spoken enough. You go ahead, David.
Sorry, go. I think I didn't mean to talk over somebody else. I didn't mean that they were saying that. I just think there are businesses that we've dealt with that, when push comes to shove, they would prioritize other things. And I think that by making it subject to availability, we are creating a loophole where it's not necessarily prioritized. And it might be easier to say, oh, it wasn't available. Furthermore, I think subject to availability is already implicit. What would happen if a worker complained to the Department of Labor and the employer could show, look, we had a nationwide shortage of these things. The employer is not going to suffer any penalty as a result of that. So I'm just concerned that these are sort of creeping loopholes that could potentially water down the effectiveness of the bill and, the public health.
How small might some of these businesses be that we think ought to be included, and how leveraged in terms of their own financial conditions might some of them be?
When it's a catastrophic statewide emergency, I don't think there's any employer that should be exempt. Everybody could get sick.
In some cases, they're so leveraged and so small, they'll be the first things closed.
And let me just
jump in. That's why the state needs to help.
No, I understand that. Let me just jump in. We know we've got to look at the definition of the employer and the essential employee, and we know we're going to have to go back to that. I appreciate the fact that my chair is bringing that back up. One of the things that for me within this that I've heard, and I hope that folks are talking about, rather I'd like to go back to, is the also just like the lack of guidance, and that we do want to make sure that it is clear what is the required PPE. I think that there's some ambiguity there. I'd like for us to figure out who's responsible for making that determination, and that they do make that determination, and that is a part of helping everybody, for people to understand sort of like what it is that we need and what we need to protect people in this in this situation. And I think that there is also some within us, we're talking about the need to figure out a way to work through the availability conversation. And we'll try to come up with some thoughts on that. I think that's my thought.
If
Senator,
I could
add, Senator, could I just add to that real quick? Not only availability, but certainly cost. Keep in mind that larger businesses that buy in quantity certainly had better access to PPE than smaller companies that didn't have to buy as much. So I think that needs to be in consideration with what you just mentioned as well, too.
Okay.
Okay, and if I may, this is a public health issue, and we should think of it coming from public health and going forward, as well as a balance between what businesses need and what employees need in order to be safe. But if we do have certain companies or businesses that we say, okay, then you don't need to do the PPE, that's just furthering the spread of the problem, not helping curtail what we're trying to do in the larger public. And as I look at, if there are the loopholes for the businesses, well, if it's available, if it's not, well, what's the loophole then for the worker not putting themselves in harm? The reason that this bill came about is because for months and months and months and months, we have had workers who were in jobs, whether they were, from the small to even the state jobs, without proper PPE, being exposed, being sick. We've had workers die, we've had families disrupted, and we need to have something in place. Yes, you all know now how to come back, and we're all doing this the right way. But last March, April, May, June, we didn't know how to do it the right way. And that's what this bill is also trying to say. I think it was Senator Augustine, this is the floor, and from the floor we build up. And we have to have, if businesses have a caveat that they don't have to provide this, then their workers need to have a caveat that, I'm not going to lose my job, I'm not going to be penalized because I have no PPE. So we have to look at the balance between both. And what I was trying to do yesterday was actually go through the millions of dollars that have come through by federal government and by the state government, what has been provided to businesses. And I think that Senator Kelly's asking that appropriately, is how do we align all the money that we are giving, millions, almost billions from the federal government to Maryland businesses with whatever you may be requesting of them? Like, let's align the money and let's make sure that our small businesses have just as much ground for getting money as some of these other big businesses that have. So, there's an alignment problem too. Thank you.
I'd like to jump in if I may, and that is that I want to state a sort of overarching piece that business wants to stay open, right? I mean, I think there's an assumption that business wants to stay open. And in fact, I can speak to certainly in Prince George's County in the DMV region that businesses want to provide a safe environment for its workers. Now, I know there's some bad actors out there. And there are some regulations and there's some government agencies that in fact that, should then go after those bad actors and then make those bad actors comply to make sure that they provide safe environment for workers. But I can tell you that, many of my members, and I'm sure, the Maryland Chamber, who's more statewide, that many of, I would say the far majority of those businesses want to keep their workers safe and want to provide a safe environment. So I really think it's important, given earlier comments, that in fact that businesses may not want to follow these regulations. I think that is not correct. I think that there's certainly I think the majority of businesses want to have a safe environment because they want to stay in business, right? And so in order to stay in business with the current regulations, then in fact, we're going to comply, right? And those businesses that don't comply should be penalized. So I want to say that as an overarching piece. I think with respect to the PPE, I certainly agree with Ms. Edwards, and that is, instead of like the onus going on the employees, let's sort of then target the stimulus dollars that go out. And Ms. Edwards and others, we would join you in the $1.9 trillion effort that's going on in the federal government. And we congratulate the General Assembly in passing then Governor Hogan. What I would say now in the implementation of this, it's not first come, first serve, but you delineate in that the monies sent Chair Kelly to small businesses, and then also then grants that would allow businesses to provide PPE, for their employees, right? And in applying for those grants, then you have to state, look, X number of dollars is going to go to PPE for employees. X number of dollars is going to go to make sure that the workplace is a safe environment, and X number of dollars is going to make sure that the employees have employment to the extent like payroll protection program. Then that's going toward operations and going toward making sure that them employees are retained. And I think that in this bill, when the governor puts in an emergency legislation, then in fact, then grant monies are available to businesses that would allow for then monies to go to PPE, however that's defined based on the health catastrophe that's going on. Instead of just
we need to mandate that we not overlook very small and minority and struggling businesses, because they were overlooked in place of multinationals in many cases with what there was this time.
Yeah, Kelly, I couldn't agree more. And that's why, what I'm saying with even the federal government, we saw that it was first come, first serve. And so that first come, first serve, the larger businesses actually got the money way before the small and minority businesses. And in fact, what we saw is that, at least in Prince George's County, a lot of those businesses were left out of the game. So what I'm saying,
I sit on a little minority bank board, and I'm telling you, small businesses were left hurting.
That's right. So as part of this effort here, what I would say is change, first of all, empower the agencies to provide oversight to those bad actors that was provided by Ms. Fisher, to say, look, we're going to go after those bad actors. The second thing I would say, Chair Kelly and others, is that then the grant programs that are going to emerge from this, all right? So in the catastrophe, there are going to be other sort of grant programs and stimulus packages. I don't know how you put this in this bill, so I'm not providing
I
the
don't think
guidance.
you do.
Okay, it may not go in the bill, but in those grant programs, let's stipulate that then monies go toward particularly the small and minority businesses, but all businesses, to make sure that they provide the PPE for their employees and not add on additional costs and harm to business.
Right,
If I could,
and Mr. Harrington and Chair Kelly, we would have no problem with that. I think the PPE shouldn't have gone to the Ruth Chris. Those aren't the businesses that needed the help. And I think there have to be creative ways to help make this happen. And for the many businesses that are looking to take care of their employees during the pandemic. With respect to section 31604, I just wanted to point out that, discussing the working conditions, I just wanted, a reminder that HB 581, Delegate Valderrama's bill, would require health and safety regulations. So if MOSH had a standard on what needs to happen, that could provide some more clarity to this section.
Sally, do you mean House Bill 124? That's
I'm sorry, yes.
Yes.
124, yes. I need my second cup of coffee, apparently. Yeah, 124.
And there has been discussion about making sure that gets harmonized into this discussion.
If I might, I want to just say that this part of the bill really gets to a real problem, I'm sure, for the business community. And I think it's worth making the statement that when we're passing unyielding statute law, knowing that whatever we just went through, it surely won't be the same the next time around. And think about it through the lens of what the governor actually did, because we can look at history now and understand that all the things that we're talking about just on one part of this this bill, that the governor was able to, with flexibility through the executive order, work with the Department of Commerce, Secretary Schultz, to bring relief dollars to help businesses pay for PPP, and through regulation and through the executive order, help define what we needed for this pandemic at this point in time. And I think it's going to be inherently difficult, and it's worth saying it at this point, it's going to be inherently difficult to imagine every scenario and then put it in statute. I think it's a flaw with this piece of legislation. I don't know how we get there. And I don't mind being a part of what it takes to get there. I just know that most things have happened over the past year. The governor has set quite the example as to what the state of Maryland can do during uncertain times and frankly, unprecedented times, for which I don't think any of us sitting here today could ever imagine and then try to craft legislation, to match it. So this part of the bill, the reason why you're seeing, I think, the first real pushback on what it is we're doing, who's going to be defining, the environment that we're working in, is because we just don't know what the next version of this is. It may not be a pandemic. It might be an epidemic. It might be I can't even imagine what kind of scenarios. And I think it's going to demand different time. What we don't want to do, and I think it's important, and I'll close in saying this, is we don't want to put in unyielding statute that frankly ties the executive's hands in the next pandemic. That's just some thoughts.
Okay.
Once the bill is enacted into law, we might need to get all of our businesses on some kind of a state registry by size in terms of leverage and financing, as well as by numbers of employees and numbers of sites for that business. So you got an easier way of making decisions when you actually are in a pandemic, because you don't want to leave out whole categories, and whole categories got left this time. And besides, think of all the people who check you out at the grocery store. Those people aren't getting vaccines. They aren't getting anything. They don't have PPE sometimes.
So
Right.
I definitely agree with that. We got like 7 minutes left. Was there something, Laura and David, that you all felt would work in 7 minutes time so that we would get it off of our list?
Honestly, I don't think so. The only thing that maybe you could discuss the misclassification provision, which is pretty straightforward. That's 31610.
Well, Chair Davis, I'm okay for us to actually not do that. I mean, if we think that it's going to take more time so that we don't like shortcut something in the process. What do you think, Chair?
I don't think we have to run right up to 9:30.
That's what I'm saying. I agree.
If we're at the point that we need extended discussion and we simply don't have the time, I guess what I would suggest is, maybe discuss our homework assignments, if you will, at this.
Yeah.
One, I would say again to the folks that I know are listening, you've heard some of the discussion, some of the things that we're going on. You can provide us with some feedback. And then I guess I would say for those of us who are here, we just some of the issues that we've discussed and so forth, I think we need to continue to flesh that out. David and Laura, if based upon what you've heard, where we are, at some point, maybe we get a bit of a summary document of what we think we agreed to, or at least how we move the ball forward, and we can talk about that or look at that more before the next meeting. That sort of thing that's still out there. But no, if we don't have the time to really have a well thought out discussion, let's not just try to go to 9:30 just for the sake of going there.
Is everybody else comfortable with that?
Mm-hmm.
Makes sense, right?
Is it possible for the folks out there, if they have right now any problems with any of the enforcement provisions of the bill? I mean, again, there's nothing in here that doesn't look like you haven't seen before, and it's already an existing law. So is there any problems with anything regarding enforcement or the powers of the commissioner to enforce the act?
I'm not sure whether this is what you're considering, but I do have problems with workers having only 3 days to file a written complaint in order to be protected from retaliation. It's related to enforcement, but it's not. I'm not sure that's the provision. That's the section.
I was talking more about the powers of the commissioner to enforce the act. I mean, again, if you look at what's in here, there isn't anything in here really that's that different in the paid sick leave or the Working Families Act or anything else.
Mhm. It follows that.
Okay. Well, listen, I think that, oh, I'm sorry, Delegate Adams, go ahead.
No, that's all right. We're good for now.
Yeah,
The commissioner during a state catastrophic health emergency will never have the ability to actually go through and actually conduct the kind of investigations you're imagining. That's just I think that goes without saying.
Well, we could add a private right of action.
Oh, my God.
Oh, gosh. Okay. On that note.
Yeah, I was about to say, I think we're definitely at the end point.
Yeah. Definitely on that note, we are. Chair Davis, take us out.
Listen, I want to thank everybody for getting up this early and participating. I know that this is a big one, but that's why we're here. That's why, for those of us who are elected, why we ran, for those in our business community, as well as our labor leaders, we took on this awesome responsibility to stand and say we're going to represent others. So it wasn't meant to be easy. If it was, as the saying goes, anybody could do it. We're here to try to make that happen. Again, for those who are listening, I know, you all have a stake in this as well, and we definitely want to hear from you. We're glad that you listened in on this discussion, and any feedback you can provide that can help us to move the ball forward would be greatly appreciated. Again, the minority party, certainly thank you for your contributions as well. I know that you have some issues with the bill, but ultimately, if anything is to go forward, we want to hear all sides and all perspectives so we can make the best possible piece of legislation. So I've talked enough. I know the bills for the House will be coming before too long. Thank you all very much.